This is the DMCA and ACTA versus academic and professional research, how misuse of this intellectual property legislation chills research, disclosure, and innovation. I still haven't memorized that title.
I'm sorry if I'm out of breath for like the next 5 minutes. I just ran from DEF CON. I just did a presentation there 15 minutes ago, and I'm back here. So but I have a lot of energy to answer your questions now after this. I know there was a reason running across the casino floor. I have a lot of energy to do this. I have an MA, MBA, and JD. I have my own law practice. I practice in the state of Maine, but I'm also going to be practicing in Washington, D.C. soon. I have an office there. And most of my clients, actually right now, all are InfoSec companies, and I work a lot with companies such as Chris's for Chris's company, I'm talking about their First Amendment type of clients that we have. And I'm also an adjunct professor, computer science department, University of Southern Maine. That's where we met. And I'm the director founder of Reverse Space. It's a new hackerspace opening up in Northern Virginia that's connected to a private school. So we're actually teaching kids. We have a hacker high school for kids. And I have to say this is just part of my disclaimer. I'm a lawyer, but I'm not your lawyer.
And I'm Christopher Mooney. I'm not listed on the presentation material because of a mix-up, but here I am. I'm at Godsflaw on Twitter. I have a computer science degree from the University of Southern Maine, a minor in mathematics, which is where I met Tiffany. I'm also a software engineer at Craigslist.org, and I have to say now that the thoughts and opinions expressed in this presentation are not necessarily those of my employer. I'm also the current acting executive director of Project DoD, which is a 501c3 nonprofit organization that does censorship-resistant hosting and tries to provide services to the public through technology. And a lot of what we're going to be talking about today is going to come by way of Project DoD, a lot of the abuse cases we're going to talk about. And finally, if you were at DEF CON last year, I also gave the presentation on subverting the World of Warcraft API, which was interesting because last year I was worried about an entirely different aspect of the DMCA than we're going to be talking about today.
We're going to be talking about the DMCA and the ACTA, and there are two parts of the DMCA in which I've done research. One is the one we're going to talk about here, which is takedown notices, and the other one, which I'm not really ready to answer questions about today, and because there's some brand new case law that's very exciting about jailbreaking iPhones. That was an interesting case that came out, and this was in regard to the anti-circumvention measures that are put in for copyrights. If you break the anti-circumvention measures under the DMCA, it's illegal, even if you want to look at the code that's on the other side of it, and that should be fair use. What we're talking about today are the provisions for the takedown notices, such as if you say that you have a copyrighted claim and someone else has taken a part from your book or your movie, and they're using it and they're not, it's not fair use, they don't give you proper attribution for your work, you can file a DMCA 5112 takedown notice to the ISP. And Chris will tell you a little bit how that affects the ISP, but the ISP, to keep their safe harbor, which means that they don't want to be contributorily sued or negligent for the copyrighted material, so they have to go through some procedures and take it down.
Right, so there are elements of notification, and us as ISPs, if we comply with those elements of notification, then we don't share liability with the user. And then there's also a counter notice procedure to allow for abusive takedown notices to be countered. I think that's probably enough to move us forward. And
the ACTA is kind of like the international DMCA, and that's up and coming. The ACTA, if it's passed, many countries will have chilling effects like we have here in the US. I believe that the DMCA is not being used for the purpose for which it was, the legislation was drafted. So I'll tell you about some organizations, including ours, that are working to either amend the DMCA through case law or through changing the legislation itself. I'm going to give you some hypos, and at the end I'm going to tell you if it's real or not. One of these is the unfair corporate advantage. Do you think you can use DMCA takedown notices to harm your competitor? Well, here's the hypo. You run a software company. Your competitor has a very similar product, and they're going to launch about the same time as you. So if you're quick, you want to be first to market, because that's great if you have an innovative product. But your ISP gets a ton of takedown notices, and ISPs don't like these takedown notices. It's too much to deal with. They don't really want to have to consider the fair use aspects of it. Often they say they're not lawyers, and they don't want to be, so they just take your stuff right down. So what happens? Your company's or your competitor site can go down for at least 10 days. That's a statutory period in which we take down sites, complaints that we've had to in the past. So another one is silencing discussion of security vulnerabilities, and this is very appropriate for this audience. So you're a security researcher. You have some stuff that's pretty awesome, and you like O-Day stuff. So someone else, though, is doing about the same research you are. So what do you do to compete with them? Okay, you know, maybe you're better at the code with them, maybe you're not. So you decide to use the DMCA. And same thing, you flood the ISP with the takedown notices. You probably think that most of them are illegitimate, but the ISP won't know. They're not lawyers. They'll take it down, and you know that. So it goes down. The last one, and this is the one that's this is the case that we are talking about here. So I already give you a hint. This hypo is true. Let's say you've been injured by medical techniques that your doctor or psychologist used on you. In fact, maybe a family member of yours has died from these techniques. And how would you feel if you weren't allowed to put up a website commemorating your child or a spouse who has died from these techniques? Because every time you mention the doctor's name, your ISP is flooded with takedown notices. That website, effectively, that you've set up is down all of the time. So this is the case we'll talk about in which EFF has been assisting us with some work on this. So are these fact or fiction? Okay, this is the DMCA. I gave you a little bit about already in the intro about what it does, but it was signed into law by President Clinton in 1998. And I'm not going to read you the statutes. I know often these legal talks will go through and read the statutes. I'm not going to do that. The DMCA is to protect copyrights online. It was supposed to preserve fair use. Fair use, however, we believe as a result of the DMCA, and other organizations are discussing this now as well, has silenced fair use. I mean, you should be able to, for instance, I do research, I presented here last year at Blackhat about accessing car computers. There's the newer model make years have a little bit of encryption, so you can't see what's beyond just some of the basic stuff that your car outputs. And should you be able to see what your car computer is storing about you, especially in something that's similar to a black box? But if you go look, you're violating the DMCA. This is a staggering percentage, and this is what we're seeing with the ISP that Chris runs. But 37% of the takedown notices Google receives are invalid. We're not surprised by this, but we're surprised that some of the lawmakers aren't doing more about this. We need more case law. We need some legislation to be changed because a lot of these seem to be for competitive advantage. So the hypo that I gave you, if you have a competitor and you want to take their site down effectively for about 10 days at a time over and over again, every 10 days you slam them with more DMCA takedown notices. And if they're invalid, oh well, that's there's some case law that EFF is trying to set now in the Ninth Circuit in California that says that you should consider fair use. If you don't, this is misuse under Section 5112G of the DMCA. But problem with that is you have to go to a court to prove that this is misuse. You have to get an attorney, most likely, unless you want to self-represent. So it's very burdensome if you run a company or if you just have a blog to be able to handle all these takedown notices, because most ISPs will take them down. They're not like Chris's ISP. All right, I talked a little bit about the ACTA, but this has some other little fixtures to it, such as increased authority for searches and seizure at borders, and the cooperation between law enforcement agencies. So other people here, I know at Blackhat and DEFCON have talked about like laptop search and procedures, and I'm not going to go really into a discussion about that, but if the ACTA is actually, if the agreement is signed with the signatory states, it's going to be more challenging to cross the border with a laptop that has material on it that may or may not be copyright infringing. So the ACTA is going, no one really knows a lot about it, and this is something that's very interesting. It's all being discussed behind closed doors. One of the ways that we know about some of the provisions of the ACTA is that some documents have been leaked. And it's really a shame, but President Obama has not, he has contributed to some of the closed door discussions. But recently a draft was released, I believe it was in April of this year. And I think we have a link to this in our slides, but you can go look at what the ACTA says. But this is not the type of legislation that we really want to be discussed behind closed doors. Here are the proposed parties to the ACTA. There's the draft, April 10th, 2010. That was released to the public. But before then, I was getting research from this, and EFF was as well, by documents that we'd found online that were leaked. So if the ACTA is passed, a lot of other countries will have chilling effects that we are talking about here in this presentation.
So a couple notes about the talk. There's a couple different ISPs, and most people, I think, think about the last mile internet service provider, the people that would provide you DSL or cable access, and that's not the type of ISP we're talking about in this talk. However, those ISPs are also subject to the DMCA, and there are some really startling things. I've spoken with people, and there are some really startling consequences of the DMCA for those users as well. What we are talking about is the type of internet service provider that is a hosting provider. So they look a lot like providing web content. Hosting providers that provide web content, Facebook or Twitter, those types of providers. And why is this talk even relevant after 10 years of the DMCA? In our experience through Project DoD, we've seen an increasing number of ISPs that don't allow for, remember I talked about that counter notice procedure, that aren't even allowing for this counter notice procedure. As of about 3 years ago, we started to see a real ramp up in the number of users that were kicked off of providers when their content clearly showed what it was fair use. So I think the abuse is getting a little bit worse. This particular piece of legislation is being exported to other countries. There's the C-32 in Canada, which also has takedown provisions and digital lock things and everything. And then there's a digital economy bill in the UK, and of course the ACTA, which is international. So I just want to give a quick overview of Project DoD. It's DoD.net. It's a volunteer-run 501c3 charitable nonprofit. It looks a lot more like an open source development community, except that we also provide service on top of that. We're funded entirely by donations. Our biggest project right now is the hosting project, which is the project that has most of these abuse case examples coming towards us. And about 12 years ago, we started hosting the needy. And that is to say, people that couldn't afford hosting 12 years ago is very expensive. And over the years, hosting's sort of gradually moved into this commodity market. And as a result, users that host content that's a little bit marginal, or maybe even not even a little bit marginal, are seeing themselves kicked off of providers because the second they get a complaint, the profit margins aren't large enough for the ISPs to really stand up for those users. So over the years, we didn't intentionally gravitate towards censorship resistance. It's just that we didn't put profit above our ideology, and so we wound up getting a lot more of these cases. And so now, about a year ago, we started developing a censorship-resistant jurisdiction-hopping infrastructure that we're going to talk a little bit about. And we should probably mention, I'd like to note here that what Project DoD is not. We are not WikiLeaks, and we are not Pirate Bay. Those needs or issues, I suppose, are being addressed by other organizations. We are talking about First Amendment speech, and especially about critique of, in this case, critique of science and medical techniques. Right. This sort of the clear sort of fair use cases, the people that are being censored that any of us would look at and say, well, that's free speech. How is this happening in our country or in other countries? Oh, okay, I'm going to talk about Project DoD versus Federici. This is a case that's been going on for quite a while, and it's becoming very time-consuming because the takedown notices we get are over and over again for the exact same material, and we have to take it down. Until Chris decided, okay, that's it. We're just going to challenge this. We're going to waive our safe harbor, and we're going to fight this in court. And that's what we've done. So with 2 attorneys in Portland, Maine, because Project DoD is a Maine company with some servers there, and also in California. So we got some Maine attorneys that EFF recommended to assist us with this because it's a big project. And we're going to talk about the DMCA takedown abuses we've experienced through this case. Yeah, and you'll see this in a little bit, but I think that this is one of the more concerning cases of DMCA abuse that you're going to see. This isn't somebody, trying to make a commentary on an image from Ralph Lauren or something like that. I mean, this has real consequences to our health and to our society. Okay, here are the questions. If our medicine is based on science, what does it mean for society if we can't have peer review? If you can't talk about some flaws in the security, vulnerabilities you found in some code, and if you're silenced with takedown notices, how are we ever going to improve any security and, for instance, in this case, better medical health? So open discussion is silenced, and I don't think the DMCA was meant for this, but it has become that. So I'm going to give a little bit of background. This is the sort of dispute between Federici and this group called Advocates for Children in Therapy. This is all before Advocates for Children in Therapy, who's our current user, wound up on us now. So Federici is an alleged attachment therapist, which means that he treats something called reactive attachment disorder that I guess I could try and summarize it for you is basically, you know, a child is deemed to not have an emotional connection to their parent, and so they misbehave, and this is called reactive attachment disorder. It's commonly diagnosed in adopted children. And so Federici has a proposed treatment for this therapy where the person administering the treatment, sometimes the parent, sometimes the therapist, restrains the child, pins them down against their will for hours on end, and basically, I don't know, it seems like hugging and whatnot. It's weird. And then after all of this is done, after the child's been broken down, they go through this process to try and reform the bond. So Advocates for Children in Therapy is a group of people made up of nurses and psychologists and actually survivors, because this therapy has produced survivor groups, survivors of this type of therapy. They're trying to stop it. And so to give you some context, there's a Law and Order episode out there. I don't know if maybe some of you have seen it, but it's about a girl that's smothered in a blanket as part of a therapy session, and she dies. And that's based on the case of Candace Newmaker, who was a young girl that was suffocated and killed as a result of this treatment. So Federici legally engages Advocates for Children in Therapy for libel and slander because they're trying to stop his practice. So Advocates for Children in Therapy decides they're going to restructure their page so that people can draw their own conclusions. They're going to essentially make an academic argument and use quotes and whatnot. And this is partly because, because that's a good idea, and partly because truth is a protection for libel and slander. I'm going to give you an example of something that was DMCA'd off of. So this is one of Advocates for Children in Therapy's sites. So you can kind of clearly see that there's some quoted text over in this area, and then there's an academic citation, and it gives the page number, the publisher, everything that we were taught to do in school, and everything that copyright law clearly tells us is fair use. Enter the DMCA. Federici finds out about DMCA takedown notices, and he files a notice against Advocates for Children in Therapy who are currently hosted or were hosted with this Ma and Pa hosting shop. So Advocates for Children in Therapy are kicked off of this Ma and Pa hosting shop without the ability to even file a counter notice. So they wind up moving to a large provider that will stand up for them, and they go to Network Solutions. Well, Federici files a takedown notice to Network Solutions, and again, they're kicked off without the ability to file a counter notice. And the significance of this time is that I guess the legal department at Network Solutions got involved and decided no, they shouldn't. I remember this is this content, right? They shouldn't have the ability to file a counter notice for this content. So Federici gets the content taken down, and they move to Project DoD.
And here's a legal procedure, and this is where it's taken, it's really been over a year that we've been trying to keep this content online, and it's really just, this is medical critique. It's not just our clients on Project DoD with ACT that are experiencing this, but leading magazines that, if they have bloggers from the magazine who are discussing attachment therapy, and with Dr. Federici's name associated with it, he gives them the takedown notices too. And they have a big legal department, so they fight it. But if you didn't have those type of legal resources, going through this procedure on your own would be just very difficult. And well, here we go. So takedown notice is filed. The entire site comes down. So there's no critique anymore. ACT stuff is down. We allow for a counter notice. Take it down for 10 days, content comes back up. The upstream provider gets harassed, and that's when we call the AFF for some assistance. And they were fantastic. AFF has been very helpful to us. They're not co-counsel, but they have been advising us on this case. So Federici has some other doctors send more takedown notices, and for the exact same stuff, for the exact same pages. This is not what the DMCA was intended for.
Yeah, and I just want to point out, too, that our major contribution at this point to censorship resistance is simply that we followed provision number 2 here, which is we allowed for the user to file a counter notice. In our experience at this point, the vast majority of internet service providers aren't even allowing this to take place. I'll give the exception to Google. They tend to do better with this, but most of the other internet service providers, as we'll show later, have problems with this.
So 6 months goes by. We're like, okay, great. Okay, maybe this is fine now. We're all right. And then Dr. Federici has an attorney in Virginia file a takedown notice for the same content again. So here we go again. So we now decide to use, that's it. We're going to fight this. We're going to waive the safe harbor provision. We're going 5112F, which means that if we win this, attorney's fees, I'm pro bono. Actually, all the attorneys on this have been pro bono. But if we win this, we get attorney's fees covered too. But it pretty much says that if you file takedown notices that you know are fraudulent, you can be held liable for that. So the arguments are made in main court, and they dismissed for lack of personal jurisdiction. It actually was a little procedural, kind of like a thing in the case that we are working on, but we are going to appeal in Virginia. That's coming up. So Federici files another DMC takedown notice, third time, same content, and we're now going to Virginia to pursue this. So common abuses for this. Fair use is not a magic bullet. It's a shame because under copyright law, one of the things that was really important, if you are going to be getting protection for your copyrighted material, you must allow for fair use. It's part of the trade-off. Just like for patents, you must make a disclosure of the secret thing that makes your thing special. But if you don't have fair use, there's some copyright material that you're not going to be able to access. So the statutory waiting period is equivalent to a denial of service attack now. I mean, that's similar to the one of the hypos that we used, if you, as we've seen from the Google statistics as well, that we showed in an earlier slide, this is being used for corporate advantages, and this is not legitimate use of the DMCA. So the backdoor takedowns, Chris is going to talk a little bit about that as well, and this is an endless chain of attacks. If you didn't have a pro bono attorney, doing this for over a year becomes like a part-time job, and the ISPs aren't willing to take that on. So leveraging a counter notice to discover one's identity is another thing we've noticed that has been really unfortunate, is that this is something that, as an attorney, we didn't expect this, but any of the pro bono attorneys, shall I say any and all, that have assisted with this case, we've experienced some pretty serious online libel, and we can pretty much tell whoever is doing it has been pretty sloppy with the IP address. Again, we're also hackers as well. We, of course, all legal, but we've traced IP addresses, and it looks like this is related to this case. So all of the attorneys have had some problems with libel who associate themselves with this case, and that's unfortunate. But when we file a counter notice, sometimes there's some women who are trying to hide their identities because it seems like a lot of the libel is mostly toward the female attorneys on the case and the female plaintiffs. So there's a woman who would like to challenge this, but she's afraid of the type of libel that we've all experienced. And so having to reveal her identity has been something difficult, and in fact she decided not to join because of that, because for the counter notice it's something that we need to put on there. And the ISP's liability, this is difficult. Not all ISPs will do what Chris has done, so he's done a really great job standing up for this, and it's what Project DoD is all about.
Yeah, and I'll talk more about that later. Just that linking a disinterested third party that cares about profit to whether or not content stays up is just a bad idea.
We have Lentz versus Universal coming up. This is a case that EFF is working on in California. And if this case, I believe, is still in the appeals process, it's not complete yet. But we're hoping the resolution for that will be that you must consider fair use when you file the takedown notice. The complicated part of that, though, is to determine if it's fair use, you're most likely still going to have to go to court. Your ISP is not going to really, I shouldn't say is not, but most likely not going to stand up for you and analyze this stuff. Fair use is getting hard to determine as well. When you talk about, like for music with sampling, and it becomes a legal argument. Did you take the heart of the copyrighted material? But in our case, we found it was a lot easier. You should be able to say a couple sentences from a book that someone has published, or from one of their public presentations. They said this. If it's properly attributed, that's fair use if you use it. And for critique purposes, it's even a stronger protection. So it's hard to use fair use as a defense against the DMCA, which is a shame because it's not what the DMCA was supposed to do, I believe. But in our experience, 5112F is hard to use, and we have some jurisdictional issues with 5112F as well.
I know, which I think the jurisdictional issues are going to get interesting if there's the ACTA is passed, because then you're talking about takedown notices being filed from people in other countries. Where are you going to wind up resolving those cases? And
We've had that problem already. We're getting some stuff from Australia. As you know, you've perhaps been reading that Australia is becoming, the censorship there for material is becoming really challenging. So we're getting some takedown notices from Australia. We're thinking, wow, that's going to be really complicated, considering international law, how and if we're going to respond to that.
Another thing, too, that I just, when you guys leave the talk and you're looking at news articles online is that when you see a lot of the, I think it's great that there are some wins happening against the DMCA at this point, but a lot of them are related to fair use. And just like Lens versus Universal was, but fair use is really something that you need to fight in court. It doesn't stop this sort of pre-court, guilty until proven innocent attack on people. And so it's great if you want to defend yourself in court, but the real trick, and trust me on this, is to stay out of court, period. It's time consuming, it's expensive, it takes forever, so we need something that helps people stay out and not be legally engaged. So I want to give some examples that we've come across of fair use abuse. In 2005, we hosted 2 domains, walmart-foundation.org and the 700club.org. We hosted them for about 2 weeks. They were, the 2 people that made the sites were part of a subversive media class at Carnegie Mellon University. And they had made the sites as a sort of social commentary on these 2 nonprofit organizations. There was a good satire. The articles were funny, but it had the same sort of look and feel, the same way you'd see like on The Daily Show or Colbert Report. Anyway, Walmart and the 700 Club filed DMCA takedown notices for this content. And of course, to maintain our safe harbor, we said, okay, well, the content has to come down, but you guys can file a counter notice. And these 2 users, they're students, they're art students. And they really struggled with the idea of trying to file this because, of course, it's fair use that they have to defend. And if Walmart or the 700 Club wanted to take them to court, they'd be up against the legal might of those organizations. So fair use is tricky. It's tricky to use to defend this stuff. So the content went offline and never came back up. And so then the other one, of course, is Project DoD versus Federici. And by the way, the reason we covered Project DoD versus Federici in the beginning of the case is not only because it's interesting and we can talk about it and I think people will find it interesting, but Federici happens to hit every single abuse case that we're going to talk about. Like, he's really skilled at looking at this and finding, think of him, he's like a security researcher, but for law. So he finds all these flaws and winds up abusing them. But just further proof that fair use is hard to use, he started and engaged us after the Lens versus Universal finding, which said that, it's a misrepresentation, or I should say that it's a necessary precondition to the elements of notification that one must consider fair use. And so that didn't stop him.
This is where we're talking about with the, we're making the analogy to a denial of service attack. The 10-day period for taking the content down is a long time. And when you're talking about O days, or you're talking about competitive advantage in the marketplace, 10 days is a long time if parts of your site, and at times we've had to take down significant parts of people's sites to meet the statutorily required 10-day period. Oh, and I wanted to note that we were mentioning counter notices. If you receive a DMCA takedown notice and you don't want to go right out and hire an attorney to defend you, I would check out chillingeffects.org. When I was in law school, Chilling Effects was just coming up. Wendy Seltzer, I think she was with Berkman Center at Harvard Law School, and she was later with the FF, and I think she's a law professor now, but she was one of the founders of Chilling Effects. And Chilling Effects addresses cases like these, and they address copyright, patents, trademarks. But if Wendy created a form that all you have to do is put in some information, and it will auto-generate a counter notice for you. So it'll save you if you do choose to do this without advising an attorney. Although we recommend that you might want to do that first. But if you decide to do it, go to chillingeffects.org and you can get your counter notice right there.
Right, so here's some examples of abuse. Basically, the Federici case again. He figures out that when he files these takedown notices, the content goes down and then a counter notice is filed, but the content can't come back up for 10 days because we're statutorily required to keep it down in order to maintain the safe harbor. So what he does is he contacts 6 of his colleagues and he has them file DMCA takedown notices for different portions of the Advocates for Children in Therapy site. And as a result, the site or parts of the site are down for 2 to 3 months.
And you've heard of double jeopardy when it comes to like some civil trials or criminal. This is like dodeca jeopardy when it comes to your content. It's the same stuff over again, taken down. So this is not something that you want to be involved in if with the DMCA takedown notices as we have.
So this is another disturbing trend that we see, which is these backdoor takedowns. And essentially, there are a couple different classifications of ISP in the Digital Millennium Copyright Act, and one is as a common carrier. And common carrier ISPs share no liability with the content that a user hosts anywhere, so they don't have to comply with the takedown provisions. They just get their safe harbor. The other type of ISP is like Project DoD, where the content actually resides on the box, so the ISP is in control of the content. So I just want to be clear that there's those two types of classifications. Now, the second classification of ISP is required to register a designated agent with the Copyright Office. This is so takedown notices can go to that designated agent. And for Project DoD, I happen to be the person that's registered as the designated agent. But there's no specific wording in the DMCA that tells the person sending a takedown notice that they need to send it to this designated agent. It's just sort of implied that that's the case. And over the years, what we've seen is a de facto migration to looking up the whois record in AARON, getting the abuse contact information off the IP address, and contacting that person instead, which may not necessarily be the ISP, let's say down the chain that's in a leaf node, like that's actually the leaf ISP as a service provider. And so you can start to see there's going to be a lot of dangers here. If just a handful of providers are the ones that are deciding whose content stays up, we have something that looks a lot like media consolidation in the late 90s. They are going to be exercising editorial content over what you host. And as a side note, I also wanted to talk about anybody that thinks they're going to get DMCA takedown notices. This is just from my experience. Anybody that thinks they're going to get them and has an ISP or is hosting content, virtual private servers may be a really bad idea because if you're on a virtual private server, the content that you're hosting is actually in the control of the ISP above you, which makes them not part of the former classification of ISP as a common carrier, but makes them part of the classification where they actually could be liable for the content. So beware of like cloud hosting, cloud storage, virtual private servers. If you're going to be hosting content, that's a bit risky. So I have a couple examples of backdoor takedowns. Actually, I have one example of a backdoor takedown. But over the years we've been doing this, we have way more than I can possibly enumerate here. In fact, it's been the #1 reason that we've been kicked off of providers over the last 12 years, from corporate providers to like nonprofit collectives. We've been kicked off of a ton of different internet service providers. And never for content that you would think is, the type of stuff the DMCA was crafted for what the MPAA would like file sharing or movies or whatnot. One case really stands out though. We used to host this site called hackblock.org, and they're still around. I think they're like a Chicago 2600 group, or maybe they started out that way. But anyway, it's a hacking collective, and they publish a zine. And they found out about a particular individual that was trying to get members of their organization arrested by entrapping them and whatnot. And they had a bunch of dialogue between this individual and law enforcement, and they put it up in their zine to show people like, look, this person is trying to entrap us. He's trying to get us arrested. So this individual does the AARON lookup, finds the IP address, and files a takedown notice. But the takedown notice doesn't come to us. In fact, it doesn't even go to our colocation provider, which is the upstream provider of us. It goes to the upstream provider of our upstream provider, which was AboveNet at the time, which is a large organization and definitely enjoys common carrier status. Nevertheless, AboveNet winds up exercising editorial control over the content and says, take this down or all the users are going to be shut off on your box. So we tell the user, take it down. And so what they do, and this is pretty common, they put in the place of the thing that was taken down the actual DMCA takedown notice. It's a sort of way of saying, look, the DMCA is being wielded to silence our fair use, our free speech. So they put that up. And a day later, AboveNet receives a DMCA takedown notice for the DMCA takedown notice, the original DMCA takedown notice. But rather than being outraged that this would happen, they actually get livid with us, and they tell us, we're not going to play whack-a-mole, take this content down, this is your last warning, all of your users will be shut off. And so ultimately, they exercise editorial control. Now, today we have a much more functional relationship with our upstream provider, where with Silicon Valley Web Host, at least in one of the nodes that we have, and that's where the Project DoD versus Federici stuff happened. And when he attempted to backdoor us, he went at the upstream provider after we had allowed the user to comply with the counter notice and the content came back up, and he tried to get the ISP to take it down. And they came to us and we said, no, you're a common carrier, maintain your common carrier status. We've already been through the process of all of this. The content is clearly fair use. You don't need to involve yourself. Well, they told Federici this, and he came back and threatened them more, and they got right on the edge of kicking us off. And then we contacted the EFF, and the EFF stepped in and said, okay, no, look, you really need to stand up for these guys. They're doing the right thing. Don't worry, Silicon Valley Web Host, if you suffer liability as a result of this, we'll back you up in court. And so they said, okay, we're a common carrier. And of course, nothing happened to them.
So again, endless chain of attacks. It's like the shampoo, directions, rinse and repeat over and over again with the same stuff. So, and the problem a lot of ISPs also have is it takes a lot of time to verify that these are new notices, in fact. So a lot of ISPs won't even read, it's just, okay, it's a DMC takedown notice. Okay, this is a problem, we'll take it down. And we found more times than not, ISPs they're not even going to look at it. It comes right down.
And of course, Project DoD versus Federici is an example of this. Federici winds up, after the content has come back up, sending us in their takedown notice, which is originally what prompted us to follow 512F and pursue him in court to stop him from doing this. And that's not just this one user, right? And I should also say, really think about it. Like, what for-profit ISPs are really going to use 512F to defend their users, right? This is expensive. You're talking about, we've already been engaged now for like 2 years plus in court with this person. And we just thought that, this was the right kind of case to stand up for. And this particular person, Federici, has silenced all dissent of his medical practice out on the internet, period. You cannot find anything that talks about the dangers of this stuff with his name attached at very least. And all of those users that he's silenced have slowly migrated to us over time. So anyway, we get through the case and it's thrown out in Maine for lack of personal jurisdiction. And he sends us a third takedown notice. So now we're on our third takedown notice from him, and the thing is, it's still really time consuming because we have to go through every single thing and say, okay, is this something he's already noticed us for before, right? And there's no provision in the DMCA that says you can't do this. There's maybe an implication that you can't because of the 10-day denial of service attack, but there's nothing in there that says explicitly like this is abusive process or something.
And using the 5112G, we think that it has been used so he can figure out who his online anonymous people are who are critiquing him. So if someone has a handle and he's been sending the DMC takedown notice to the ISP, and the ISP, well, such as us, we're not going to say, hey, that handle is this person's name, here's her name. He's using this, we think, to find out who she is, so he could also sue her for libel or something like that. So we are finding that the DMCA is being used to really destroy people's anonymity online. And as I mentioned, a lot of the female attorneys on this case and the women who want to be plaintiffs are really concerned about some of the stuff that's been going up online that we've been able to trace has been coming back related to this case, most likely by attorneys, or we've actually found some evidence that it might actually be some Russian group that you tell them you want this name libeled, and they'll libel it, like they'll set up a fake Facebook page, like for me, for instance, and it's loaded with Russian malware. So it's that type of stuff. There are not a lot of attorneys or plaintiffs who want to stand up to that. So it takes a lot of gusto. But this isn't fair, where we're having to, if we want a counter notice for this user, we have to put her identity in the counter notice. We're not having a good time with that.
Yeah, and so this isn't required by the takedown notice, right? So there's agent wording that makes the person that's claiming their copyright has been infringed, allows them to hide behind a firm or something else. There's also specifically a section 512H which requires a court order in order to get the identity of the person. However, the counter notice doesn't require that. The counter notice explicitly wants the personally identifying information. And so what we saw, and this is in a separate case, like I said, remember there's a bunch of people that came to us. This is a totally different domain. It's a support group for survivors of this type of therapy. So I can say she, so it turns out the gender of this individual is known. She runs the site stopchildtorture.org, and she puts up this NBC video. Well, she actually had it up on YouTube, and YouTube DMCA'd it, and she didn't want to lose her identity, so she wasn't able to counter notice. So she put it on us, and the NBC video basically just talks about, it's like one of these hardline videos, talks about attachment therapy, and you know, it's sort of like a 2020 piece, right? And so she puts it up. It's NBC's copyright. It's not his copyright at all, and he files a takedown notice. Now, what she's doing here is trying to compare the holding techniques illustrated in the video with this recent case that says these things called face-down takedowns, they're like security guards in schools use them for kids, are potentially lethal. And so security guards in school are no longer able to do the face-down takedown on like high school kids, right? So she's saying like, look, well, this is the exact same type of holding technique, like isn't this also potentially lethal? And so, of course, he files a DMCA takedown notice for it, and so we have to take the content down. But this time, when he filed it, he sort of specifically says, like, and if this person's going to file a counter notice, which he knows they're probably going to, they better include their personally identifying information. And that's when we found out, oh, wow, look at that. The statute actually requires personally identifying information for the counter notice. And so ultimately, the content stays down because our user wasn't willing to release her identity. But what she did is she wound up having the content hosted on a service called VideoWeed, which is outside of the jurisdiction of the United States and therefore does not need to comply with these sort of DMCA takedown notices. But she has a bunch of ads that pop up when you go to that page now.
So the liability is a failure of the DMCA. It seems like what's happening is if you have a very passionate argument about something and you want to talk about it online, and someone doesn't want you to, you use the takedown notices and it will most likely come down, as if you are using copyrighted material to make your point. And when the ISPs are motivated by profit and they're not non-profits like Project DoD, it's difficult. They're most likely not, this takes too much time. They're not going to stand up for you. And also, we have some users that they've lost their Twitter accounts, their Facebook accounts. Those have been DMCA'd as well. Those are down, but at least some of the content for the websites or our blogs, whatever, resides on Project DoD. We've been able to preserve that, while Twitter and Facebook, it's come right down for the same type of content. So if this continues with this trend with the takedown notices, we think it's not heading in a good direction.
Yeah, and I think this is an important one to me, just because it seems obvious to me that if you have a dispute with somebody over content, that the two most interested parties should really be the ones that should handle that dispute. And the second you try and tie the liability of a third party that only cares about liability to the content, you really don't have a sort of a world that's going to facilitate fair and open discussion of anything. So I don't know if Tiffany would say this as strongly, but I think fundamentally that the takedown provisions of the DMCA, the sort of guilty until proven innocent approach with market pressure, and I don't think this is a mistake necessarily, I think that that's probably the biggest failing of the DMCA's altogether. Well, okay, I shouldn't say the DMCA, but I think that that is a failing that's larger than any of the ones that we talked about before, which is simply that really the ISPs should not be sharing liability with the content. Just like everything else out there, they should require a court order to take it down. And so I'm not going to get into too many examples of this, but I just wanted to say that we've entered this de facto state of censorship out on the internet, and we've seen all of these providers and many more take down people or users on their service, not allow them to file a counter notice, and they've wound up on us specifically. So, and this is WordPress, GoDaddy, Network Solutions, a bunch of other smaller providers that have had this happen. So, can technology fix these censorship problems? Well, There might be a couple technical solutions. We're going to give a quick overview of Tor hidden service, and I want to say thank you to the Tor folks for letting me use their slides, or use the images to illustrate how hidden service protocol works. Now, I'm going to assume that most of you in the audience know how Tor works in general, how circuits are established. This is just sort of like plus on that. It's like a one step up, like how you can use it to provide a service from Tor. And I'm also going to talk about jurisdiction hopping solutions. And then we'll talk a little bit about direct action. I think you guys will have fun with that one. So for our intents and purposes, we're going to consider Alice to be the user and Bob to be the ISP. Bob is going to create a circuit into the Tor network, and he's going to choose 3 introduction points. And then he's going to list those introduction points with his public key into a directory server. Alice is then going to look at this directory server and for an identifier, which is usually something like foobar dot, well, it's not an easy name. It's some obscure identifier dot onion. And so if you know about this obscure identifier dot onion a priori, you can go to the directory server, look it up, get the public key and the introduction points. Alice is also going to then pick a rendezvous point. And so she's going to create a packet that's basically encrypted with a public key. It has this, this one-time token, and she puts the rendezvous point and sends this through one of the introduction points that Bob's chosen, which then forwards it on to Bob. So Bob, the ISP, now gets that and meets Alice over at the rendezvous point using the one-time secret in order to authenticate to Alice, yes, you contacted me and this is me. And then they establish a secure encrypted connection. And I think the important point here is, I mean, the arrows aren't really illustrating it, but there's a circuit on either side here, a Tor circuit, that is going to protect, well, I guess I can't really hit that without blinding Tiffany. So that's going to protect the identity of both the ISP and the user in this case. This seems like a completely workable solution for providing censorship-resistant hosting, but there are actually some drawbacks to using Tor. And I don't know if any of you have used it. I'm sure you guys have actually. But if you use it, you make a little bit of a speed trade-off, right? So there's sort of an efficiency trade-off for trying to use Tor in order to maintain your anonymity or privacy. And it kind of gets a little bit worse because of how the buffers work. If there's a lot of file sharing traffic or large amounts of data going through the Tor network when you're trying to use it. And so what I want to do is kind of talk about a spectrum of users, right? So you have these users that are used to the commodity hosting, and you have users that if they publish their content and their identities are released, they're dead, right? Their governments will kill them. And I think in the former case, the commodity hosting providers do a good job at offering those services. And in the latter case, I think Tor does a really good job. It makes a good trade-off between trying to publish content and also protect the person's identity. But we're in the spectrum of users. We have these users that we've been talking about, right? The ones in the abuse case examples that fall in between. And those people need something that's maybe still a little bit fast, that looks a little bit like traditional hosting, but doesn't suffer all of the censorship implications. And there's another problem with that onion identifier, right? And that is that it's a little bit obscure, but this may be not necessarily a design flaw, but sort of mathematical truth, right? So there's this thing called Zuku's conjecture, which says that one of these names cannot be human, meaningful, secure, and decentralized all at the same time. They can only have 2 of these 3 elements. So there's a more friendly interface to this, which would make it so Alice didn't have to look up the identifier from the directory server. Alice could use a normal, say foobar.tortoweb.com. And you can, through URL redirects and whatnot, you can get a sort of meaningful name. But the second you do that, of course, you've lost your decentralized naming for something meaningful.
Another way to do this, if Chris talked about the technology, is how about through law? Can we do jurisdiction hopping? How easy is it to do? And I'll tell you, it's not easy. But One of the examples that I found most interesting, and I did a lot of research in law school about this and wrote a thesis about it, was Haven Co. and Sealand. I remember when Ryan Lackey, I believe he was the CTO or CEO of Haven Co., which is the company, and Sealand is what a sovereign nation, or so they state that they are. But they've given presentations at Hope and at DEF CON, and I'm not sure about here at Blackhat, but this was an offshore gun platform that was used during World War II, and is off the coast from the UK. And a group of people that were into pirate radio at the time took this platform, they claimed by adverse possession. Although being that it was owned by the government, you can't really own government property by adverse possession, but the UK at that point didn't really care. The pirate radio station actually was a big deal. I think they made a movie about, in the movie it was set in a boat, but I read it was really, this was what the inspiration was Sealand. So there's a king and a queen and a prince, and they have their own passports, their own currency, stamps. Those go for quite a bit, but it's quite interesting that they claim that they are a sovereign nation, and under international law, and law of the sea actually applies to this as well, is how far off are they off the coast from the UK? And at the time, the UK, their international waters were not, it didn't cover the platform, but since then they've kind of bumped it out. If you look on a map, it kind of goes out around where Sealand is. And Sealand, I believe it was in like 2000, during like the dot-com boom, they decided what they were going to do was do internet, like hosting, a hosting company there, and that was called Haven Co. So Ryan and Avi went out there and set up this company, and they had a lot of servers out there. They claimed that they would not reply or respond to any U.S. Subpoenas or warrants that were issued. Now, their connection to the internet, though, was a cable under the ocean. They were saving up to be able to get a satellite uplink, but I don't think that happened. So one of the biggest vulnerabilities for them was that for their internet access for all their clients, it was a cable under the ocean. At any time, the UK could have severed that connection. They didn't have I don't believe at the time, I don't think they had a redundancy. Another problem they had is the king and the queen, they had universal health care over there, and so if anyone's been to the UK, part of your citizenship of the UK is you're like, oh, okay, I have socialized medicine, I'm a member of the UK. So they got their health care in the UK, and that was something that was a little bit weak for their sovereign nation argument. But one of the things that I remember when I talked to Ryan about this at Hope, I think this has got to be like 3 Hopes ago, when they did a presentation, is what would you do if you received a subpoena? And a Wired article came out, I believe it was in 2000, that was it's claimed they had lots of guns on the platform. Also said that the rooms in which they had their servers were full of argon. So if you really wanted to go in and take a box, you had to put on a mask and all that. Well, I don't think Ryan said the argon thing may not have been true, but it was kind of just to ward off some threats. And the guns, I think those were true. It's difficult to get there. You have to take a helicopter or like a really scary boat ride out there. But were they subpoena proof? Well, I believe it was a year or two ago, the king and queen of Sealand wanted to get the UK to declare them a sovereign nation. And they had a petition going, I believe, with signatures and all that, and they were not successful. And then they had a huge fire, and Sealand was burning. And who came to save them? It was the UK Navy. So they put out the fire, and relying on that type of infrastructure with the UK weakened their jurisdiction type of argument a little bit. But what was difficult was I think I haven't found an example, whether it's Sealand or it's servers in places where the U.S. is going to have trouble if they have subpoenas or warrants they want to serve on people. I would never say that it's subpoena proof, subpoena resistant, just like we are censorship resistant. Proof is difficult to say. So is Sealand a sovereign nation or not? The arguments that I've seen, the academic arguments, even go as far as it's a platform and it's on a pylon that goes into the sea, and it sits on the shelf. This is law of the sea. That is part of the shelf for the UK. Now, whether it's connected, like actually in the shelf, or I looked at some drawings of how Sealand was built, but it was like a boat they sank. This was back in during World War II era. They sank a boat and sand and stuff filled it. So Are they their own nation? It's hard to say, but I've read, there was also, I got to mention, there's a great article in Wired about floating islands that are in international waters. So jurisdiction hopping in the future may be some way that you might be able to have censorship-resistant locations. But short of having your own army, I suppose, and your own laws, it's challenging. It would be challenging. But right now, I think it's hard to say that anything is subpoena-proof or jurisdiction, that it's its own jurisdiction that can't be served or found by the U.S. or whatever your government is that from which you originate. But when I talk about this, if you are looking to do jurisdiction hopping, I do know there are services out there. In fact, we have a box in Sweden right now where we're putting some stuff such as some content about the case that we're telling you about now. And we're not doing it to obstruct justice. With proper warrants and subpoenas, it's reachable, but it's more difficult. So if you have well, it's possible, like I said, it's resistant but not proof of these subpoenas and warrants being served for us to turn over or shut down content on a box in Sweden. Iceland is also becoming a country that they're claiming to be a haven for data.
So I want to talk a little bit about what we're working on with regards to jurisdiction hopping. So we're pulling together a bunch of tools that are trying to build this censorship-resistant infrastructure. And we have development nodes in San Jose, we have them in Oakland, and we have one in Sweden. Right now, everything is under our control, but at some point in the future, I'll talk about the principles of this, that needs to not be the case. So, of course, our hopes are that we can gain censorship-resistant hosting, maybe subpoena resistance through this. And that really what we're talking about is something that feeds that middle spectrum of users, right? That this is a sort of stopgap solution to getting on something like Tor where everybody can use it and it's functional. So we call these things server cells because they're named after like guerrilla resistance cells. Such that they have the principle that no one cell is a strategic asset that can be taken down. So you can lose 1 to n cells and content won't suffer interruption. And so you can kind of see, oh wait, you guys will enjoy my diagrams. This is just engineering paper with pencil and I scanned it and then threw like some Visio stuff on top because I'm really bad with Visio. So here's the internet. We have these cells in Oakland, San Jose, and Sweden, and they're connected through a virtual private network to data sharing. So there's a couple of principles. One is distribution of responsibility, isolation of control. So an admin should have control over only their cell resources, and the user should have control over the resources they provide on that service as well. So if I'm the admin and there's a service, call it an HTTP service for foobar.dod.net, and it gets a takedown notice, I can actually say, okay, well this can't be hosted in the cells that I control under my jurisdiction. So I can say, okay, this is going to be in San Jose or Oakland, but it can still be provided in Sweden. Now this is in the case where we're still not in control of the Sweden box. Now, but the user can say, hey, you know, Sweden's way too far away, I don't want to offer my content there. And they can not offer that content in Sweden. And this is sort of the case for an Australian user that we have, that they don't want to offer the content in their country because, well, you guys should pay attention to Australia. They're getting right up there with Iran and North Korea as far as their internet privacy laws. So then the other principle is that we should have redundancy of data. That is that it needs to be in more than one jurisdiction at a time. And that a resource should have jurisdictional resilience. And part of the redundancy of data is the jurisdictional resilience, but that it should enjoy jurisdictional diversity. And there's an important thing here is that no individual or organization should be in control of all nodes of the network. If they are, then in certain cases, you know, something that's hosted in Iran or Australia, if an admin is there and they have access to the boxes in Sweden or somewhere else, then they can be coerced into releasing information or taking that content down. And so the principle here is that you wind up with different sets of individuals and organizations in different countries, all in control of cells that work off the same infrastructure. And so that's what we're trying to build, is something that's open source enough that people can set it up and then a community of people that can join together to offer this. And we could certainly use developer help, so if any of you are interested. And so I think you guys are going to like this one. I'm going to go a little bit fast, but I want to do a thought experiment. So again, I want to remind you of the guilty until proven innocent 10-day denial of service attack, the backdoor takedowns, and the endless chain attack and ISP liability. So all of these things are problems that we've outlined in the DMCA. So I want to pose a couple of rhetorical questions, which is that what if we treated those problems, what if we treated those failings as protocol failings, right? So what if we actually say, oh, well, this is just a protocol. This stuff is vulnerable to attack, as we've demonstrated earlier. And what if we treated our lawmakers like software vendors, right? So we tell them, hey, this stuff, this is a problem. And what if proof of concept code could be used to highlight DMCA protocol flaws, right? So this is how could we, or could we use software to really take advantage of these flaws and show that this stuff doesn't work, that the protocols that they've outlined in the statutes are flawed. So responsible disclosure, most of you probably know this. So it requires that, say the vendor releases buggy software and then a security researcher finds some sort of theoretical vulnerability, informs the vendor. The vendor chooses not to fix the bug. So the researcher winds up releasing this as a white paper, whatever, to the public saying like, hey, look, this could probably be leveraged as a problem. And then the vendor still does nothing, maybe perhaps arguing that the attack is too theoretical, that it would never work. So the researcher writes proof of concept exploit code, and then this last item I said, the vendor must fix the bug. That's actually not the case. They can probably write a DMCA takedown notice and prevent the researcher from releasing this stuff. So here's the theoretical attack. We're going to imagine what happens if we amplify Project DoD versus Federici. That is, that it's not just him, but that all of the things that he highlighted, we're going to take advantage of those, but on a mass scale, right? So lots of people. I want to posit a malicious actor named Mallory, and then I'm going to throw together, just design, or maybe use a bot network of nodes that can send well-crafted DMCA takedown notices and follow-up notices to multiple ISPs against multiple users. So think of this as a sort of web crawler that goes around, finds content, creates these takedown notices, and fires them off in mass to all these ISPs. So we have a couple of requirements. One is that Mallory's identity stay hidden, and that any node that sends the takedown notices cannot be tracked back to her. This is like basic bot network principle stuff. But that the nodes themselves need to be exposed. They can't be like behind Tor or something like that, because that's statistically interesting information. So the abusive takedown notices must look like legit notices. So you can use random looking letterheads, say off chillingeffects.org. You can throw together whatever you want, as long as there's statistically, and this kind of goes towards spam fighting, right? As long as they're statistically indistinguishable from real takedown notices. So then you might even put anonymous contact information on, so like a prepaid cell phone or VoIP or something like that, maybe Tor access to an email account. And then when this thing sends notices, it needs to send them to all first-order ISPs. And when I say first-order ISP, I mean ISPs down at the leaf nodes. If you think about it like a tree, although it's more like a web, but if you think about it like a tree where ISPs sort of have a parent, you want to send takedown notices to all those first-order ISPs. But you also want to send them to the nth-order ISP, so you want to go up the chain so that you can do the backdooring attacks under certain conditions. That is, where the content is still up, or when it goes down and then comes back up. So so you have those two conditions to send takedown notices, and then there's a sort of side effect that's kind of interesting here, which amazingly enough Federici also highlighted, which is that you can send a takedown notice to a search engine, say Google, and get the content removed from the index as well as the cache. But the interesting thing here is that Google doesn't have a user for that content, so there is no counter notice procedure, right? So you send a takedown notice, it gets removed from the index or or the cache, and then there's no user to say this was a fraudulent takedown. So you can basically remove the content from search indexes as well. So I'm going to talk a little bit about just let's say we'll use Gearman, right? I'll just give you an overview of what it is, but it's a distributed job processing server, and you have a bunch of clients that send a payload to a job server registered for function, foo, or whatever. And then that job server sits there and workers connect to it and say, hey, I can do job foo, do you have anything for me? And so the workers pick it up and do the work. And so all of this scales like 1 to n at any point. And what we're going to do is sort of shim this in at the 2 connection points here, where the clients connect to the job server, the workers connect to the job server. We'll shim that through the Tor hidden service protocol. This is not like, it wouldn't work out of the box, but there's an interesting project that we're working on that could make Gearman do this. So the client API is basically, you can write it in whatever language you want, and then you shim it here at the arrows. It goes to the job server. You have the shim for Tor as well over here, and the workers can pick it up and they can be written in whatever you want. And then more of my fun diagrams. So we have Mallory over here with the little horns, and she has a takedown notice. There's a Tor onion network, a Gearman server, and then a bunch of zombie workers and ISPs over here. And so what's going to happen is Mallory constructs a statistically, a takedown notice that is basically the same as any other takedown notice that an ISP would receive. And Mallory fires it off through the Tor onion network, and it lands on this Gearman job server. And then workers register for that function, so they pick it up. And so both the client connection from Mallory to the job server and the connection from Gearman to the worker was obscured through the Tor onion network. And then these zombie workers essentially can take that takedown notice, or the mass amounts of takedown notices that Mallory is firing off the job server, and just shoot them off at the ISPs. And so if we're working under the current regime, then ISPs are going to be shutting this stuff off until they realize, wow, we're losing a lot of users shutting this stuff off. We can no longer really do this. So the service provider can choose to follow the counter notice procedures, but then there's still the 10-day denial of service attack, and there's you have to take into account the backdooring as well. Like the ISP may not even be in control. So ultimately, I think if the volume was great enough, right, if somebody were to actually launch this type of attack, the volume was great enough that that these notices were statistically indistinguishable from real notices. So you have this really bad signal to noise ratio. That ISPs would be forced to ignore these notices. So the law becomes unenforceable. ISPs are no longer complying with takedown notices, and ultimately it needs to go back to Congress for a rewrite. And so this is what you need to do.
Yeah, how do we fix this? Here's some recommendations. The 10-day denial of service attack isn't working. This is a problem for content. The chaining attacks, if it's the same content, don't file the same DMCA takedown notice. This is a problem, and there should be liability associated with doing this. Let's see, ISP liability is also a problem, as Chris mentioned when he was talking about this. This is a lot to tie, a lot of responsibility for the ISP. Time-consuming liability, this is a problem if you have some speech that you'd like to get out there and the ISP really doesn't care. And their profit margins probably are going to way above your what you have to say.
So the future would basically look like the past. Right, so we'd be back to people having to get court orders to mitigate disputes, or to arbitrate disputes between to an alleged infringer and an alleged copyright holder. So the ISP is no longer in the middle of this. I'm going to skip the conclusions, and we'll just go straight to questions because we're right at the end. So you have about 4 minutes for questions. You guys can grab the white paper for this at the URL here, or the slides at at that URL.
And I'd like to quickly comment, someday your content might be the stuff that you're getting DMCA'd with your ISP. So if you care about these issues, support EFF. Public Knowledge in Washington, D.C. is working to change legislation. They're really trying to save fair use in the DMCA. They're a fantastic 501c3 nonprofit. And, of course, support us if you can. We were also a 501c3 nonprofit because maybe you want your site hosted with us sometime. And chillingeffects.org, actually, if you ever get takedown notices or patent infringement letters, Harvard Law School and Maine School of Law and like Stanford, they might take your case and help you out with answering that, helping you with deciding if you're going to should pursue that in court or not. So questions, please.
Sure.
Is Federici really making enough money off of his books and all that he can afford all this litigation?
He appears to be independently wealthy.
Can you repeat your question?
Okay.
Yeah, so is this attacker, Federici, really making enough money off of his books and all to support all this litigation? And my answer was he appears to be independently wealthy enough to do so.
It appears, we're not really sure, but maybe he has a pro bono attorney working for him too. Hard to tell, but it's the only way that Chris's company's been able to really do this is it's the censorship resistant is us, the attorneys. And if you don't have an attorney to stand up for your stuff, it's going to cost you a lot to do this process.
Anybody else? Sure.
How different does the content have to be from takedown notes? Can you slightly alter it and place it back up, or what's the process
Well, we've definitely seen tactics used on us and in other places for, like, say, I have a friend that took a picture of somebody at a party, and someone else used it as a sort of commentary on their site, and he sent a takedown notice for this stuff, and I was trying to encourage him, no, don't do that. And so that the person, this is no longer a problem. And so my friend asked me for advice, and I said, obey it. It's a derivative work, let it go. And so he sent back to the person, he's like, well, you may not respect my copyright, but I respect your derivative work. Well, this person wrote back, he said, wow, that was refreshing, and so he took the image down. Because he respected the derivative work.
All right, thank you very much. And Chris and I are going to be here for the remainder of this conference. We're going to also be at DEF CON, so come say hi to us. If you have some content that you might be interested in having us host on Project DoD, please contact us, and here's some contact info for us. At Project DoD.
Yeah.
All right, thank you.